Hello friends, Namaskaram. How are you? Myself is Dr. Soni. I am an advocate and a defense counsel. In today's class, I will discuss one of the most important judgment of Honorable Chhattisgarh High Court, which is dated 12th of March 2026. In that case, the accused was prosecuted as per Section 7, 13(1)(d) of PC Act. Finally, he was convicted by the concerned trial court and he had submitted an appeal before Honorable High Court. He submitted that the case of complainant is totally concocted. He submitted that there is a case of ESI compliances. Regarding this, there was an outstanding of Rs 60,000. Apart from that, the complainant submitted that there is no outstanding pending against him. He submitted that the demand of outstanding is unjustified and to drop the proceeding of outstanding, the accused had demanded the illegal gratification. And finally, he submitted the report. In the meanwhile, the verification had been done and finally the accused was caught red-handed. In the case at hand, there is a recovery, but it is not from the person of the accused. It is from the back. Finally, the accused had been charge sheeted as per the norms. The accused submitted that demand is must concerning the cases of Prevention of Corruption Act. If demand is not proved in that scenario, the accused could have the benefit. As we know that concerning Prevention of Corruption Act, one of the most important judgment had been pronounced by Honorable Supreme Court of India, which is dated 15th of December 2022, and subsequently on 17th of March 2023, Honorable Supreme Court in its judgment specified that every demand of money is not demand of bribe. The prosecution has to prove that a work is pending with the accused to discharge the duties in the illegal way. The accused had demanded the illegal gratification. If the factums are not supported with the other corroborations, in that scenario, a doubt is created and ultimately the accused could have the benefit. So simply we could say that demand is must. Even though there is mere acceptance, mere recovery, if demand is not proved, in that scenario, the prosecution is liable to be set aside and quashed. In addition to this, sanction is quite important. The sanction must be as per the norms of Section 19 of PC Act. The sanction must not be cyclostyle or mechanical. And apart from that, the agency is required to follow the guidelines of Honorable Supreme Court, that is CBI versus Ashok Kumar Agarwal. Judgment date is 31st of October 2013. If there is inconsistency in the testimony of the complainant and other witnesses, more specifically regarding the visit to the office of the concerned accused, and apart from that, there is a variation in the negotiation and all the factums are not supported by report, by verification, by transcription, in that scenario a suspect occurs and the accused could have the benefit. It is to be noted that in that case, no money has been recovered from the person of the accused. If money is not recovered from the person of the accused, in that scenario, we could have the benefit. And apart from that, Honorable Supreme Court in its judgment specified that if there is no recovery from the person of the accused, in that scenario, accused deserve the benefit of doubt. In addition to this, shadow witness plays an important role. If shadow witness deposed that he has neither heard nor witnessed the conversation, in that scenario, suspect occurs, and apart from that, there is lack of corroboration and the accused could have the benefit. If the work of the complainant is not pending with the accused, and apart from that, complainant deposed a false statement regarding pendency of work which is not duly corroborated by the concerned ACB or by vigilance or by CBI, then we could have the benefit. Finally, in that case, the court observed that the prosecution failed to prove the demand, the specific sanction. Apart from that, there is inconsistency in the statement of witnesses. In addition to this, there are variations, lack of corroboration, no money is recovered from the person of the accused, shadow witness has not heard the conversation, work is not pending, and whatever specifications are given by the complainant are not duly corroborated and confirmed along with verified by the concerned agency. In that scenario, accused deserves a benefit and finally he is acquitted. So whenever you are going to study your case, you have to study the same within the parameter which I specified to you as per the guidelines of Honorable Chhattisgarh High Court. So I think that I have specified you what you can do concerning these cases. So in the last, I could say to you, just review your case before proceeding further, and apart from that, whenever you are having FIR, give the proper memorandum so that you could put up your defense on record. If your defense is on record, the agency failed to investigate the scenario. In that scenario, we could chalk out the case for the info investigation and could have the benefit. And apart from that, the sanction authority is bound to apply its mind on the facts and scenario. If no mind is applied and sanction is given in secular style way, then we could have the benefit. So basic requirement is that we have to observe our file, because each and every time we could get a new point to contest. So everything depends upon us in which manner we are going to contest our case. See you in the next lecture. Till then, Har Har Mahadev, Jai Shiv Shambhu.